The Nigerian justice system is plagued by several factors that make speedy justice delivery somewhat near impossible, with access to justice being quite a challenge, resulting in the mounting numbers of pre-trial or awaiting trial detainees. As a way of addressing this challenging situation, Nigeria's Justice Minister says the ministry has empowered the 36 states to implement the Administration of Criminal Justice Act to ensure access to justice for detainees.
On a regular basis, these facilities are visited, and the inmates in those facilities are interviewed to ensure that they are not unduly incarcerated, and where they are incarcerated, ensure that they are arraigned before the appropriate courts, saddled with jurisdiction to try the offenses alleged against those that are in incarceration. And this has helped tremendously. In FCT, we have statistics to show that through this regular oversight by magistrates in FCT, that the rate of detention in detention sets, particularly police cells, has reduced drastically.
Despite the efforts of the government, the state of things in correctional services remain far from pleasant, with a total of 51,076 awaiting trial inmates, which is about 70% in custodial centers nationwide as of Tuesday, 6th of November.
A custodial center is there to host about 5 inmates, but you see that it is hosting 20 inmates instead of only that 5. These things negates as a result of this issue of access to justice.
The main thrust of this event is on court administration and case management, as well as on reforming pre-trial detention in Nigeria, with a cross-section of the speakers lending their voices to the subject.
The traditional institution which we represent is ready to play further roles in our collective quest to decongest our prisons and to preserve and enhance the human rights of our people, whether suspects or convicts.
Too many Nigerians remain unaware of their rights, unable to afford legal representation, and hindered by a complex and often intimidating legal system. Very burdensome legal system sometimes. Our waiting trial population in our custodial centers has over the years maintained a steady range of 65 to 80% of the total prison population.
Effective pre-trial case management would create a situation where the judge, the prosecutor, the witnesses, and all the parties, including the complainants, would have agreed on a timetable for the trial before the trial begins.
The main objective of this event is to provide training for relevant officials in Nigeria's corrections and judicial sectors to ensure they can effectively handle and provide necessary legal and other services to pre-trial detainees. Godfrey Eshemuge, Arise News.